Thanks, Becca. And please know how grateful we are for our twodays.com partnership and your personal effort to make sure the webinar series happens. The Drake Group Education Fund is dedicated to educating the public and professionals in our business with fact-based information, featuring the experts in our profession, so that we all might do a better job of helping college athletes realize the promise of a baccalaureate degree and becoming all they can be as athletes. So welcome to our 29th webinar. We have so much we want to cover today. 15 college sports bills before Congress, with over half addressing the current chaotic NIL situation. First, the ground rules. Each of our panelists has been asked to express their own views, not the views of the Drake Group, or their higher education institutions, or their law firms. They are all experts in their own right. We have assigned several bills to each panelist. During our first half hour, each panelist will give us a brief 1 to 2 minute summary of each bill. Each summary reflects the panelist's opinion of the most salient points and their impression of the bill. We want you to leave with an understanding of the topics members of Congress are interested in and the main points of their approach. Then we will switch gears and ask our panelists to comment on the major issues underlying most of the NIL bills, what everyone is trying to grapple with: inducements, enforcement, antitrust exemptions, NIL collectives, Title IX concerns, with panelists debating whether and how legislative policies might resolve these concerns. I've let each of the panelists know that I'm going to be a strict timekeeper, urging each to make their points as concisely as possible, giving folks a 15-second notice to close out making a point if necessary. So let's get started. First, meet attorney Brandon Sykes, the Associate Athletic Director of Admissions at the University of Florida Levin College of Law, who's also a member of the Board of Directors of the Drake Group and a former Division I Athletics Compliance Coordinator. Brandon, we have two bills related to athlete health and safety. What are they?
Thank you, Julie. I really appreciate being here, and thank you everyone for joining us. So the two bills that I'll go over with college athlete health and safety, I'll do those very briefly right now. So the first one is in the House. It's Representative Carter of Louisiana's 2nd District, and it is the School Sports and Safety Study Act. If passed, this would direct the Secretary of Health and Human Services to conduct a study on the causes of deaths and catastrophic injuries related to high school and collegiate sports and formulate recommendations to prevent those deaths and catastrophic injuries. I think the highlight of this is, one, that this would provide information that would be the foundation for future legislation or recommendations in this health and safety space with these injuries. They cited from 1982 to 2021, high school and collegiate athletes suffered 2,958 of these injuries or deaths. So from a preventative standpoint, having this information can help prevent these injuries and deaths in the future. But then also from an accountability standpoint on the back end, when these injuries or deaths occur, it allows for folks to understand whether or not organizations, coaches, other individuals were in compliance with recommendations and the things that they did or did not do. The second act that I will talk about briefly is within the Senate. And so this is Senator Klobuchar of Minnesota, along with Senator Cassidy of Louisiana. And it's the Stop Campus Hazing Act. And so this act is pretty straightforward. So this would amend the Higher Education Act of 1965 to require institutions of higher education to disclose hazing incidents, publish those reports on their website. Those reports would include things like the prevention policies that they have in the hazing space, names of organizations that have been culpable of hazing incidents, and then description of those incidents, findings, sanctions, things of that nature. One question that's come up with this act is we already have the Clery Act, which requires institutions to report on crimes on campus. And so there's a question about, like, is this necessary? And I would argue that it is. On one hand, it highlights hazing as a specific issue that needs to be addressed, looked after, and handled. But then in addition to that, not all hazing incidents reach the level of criminality that may be covered in the Clery Act. So student code of conduct, other ways that these incidents may be handled may not necessarily be disclosed through Clery. This would provide that information to students, families, accreditors, other regulators in a very centralized space.
Thank you. Brandon, we've got a couple more bills for you. Next, would you please explain the one bill that generally addresses the NCAA rules enforcement process, unrelated to NIL?
Yes, absolutely. So with this space, this is the NCAA Accountability Act of 2023. So this is proposed by, it's in the House, it's proposed by Representative Kustoff, Republican from Tennessee's 8th District, and Representative Harder, a Democrat from California's 9th District. And this would require the NCAA or any collegiate athletic governance organization to afford any individual or institution alleged to have violated NCAA rules with effective due process. And so we're talking about due process, things that are included in this: 2-year statute of limitations for bringing charges, penalty hearings must be conducted within 1 year, athletes and institutions would need to be provided with full disclosure of the programs and people under investigation, specific allegations, the rights of the accused, things like that. One thing that is important to note about, or two things really quickly that is important to note about this bill: one, it does not eliminate the requirement for institutions, staff members, athletes to cooperate with investigations. And the other thing is this does not take the enforcement apparatus from underneath the NCAA and put it in another third party to handle these investigations. This would keep the investigation process within the NCAA.
Thank you, Brandon. And one last bill for you. Would you please explain the one bill addressing the IRS tax code and NIL collectives?
Yes. So this has been proposed in the Senate by Senator Thune of South Dakota. It is the Athlete Opportunity and Taxpayer Integrity Act. And so this follows up on guidance that the IRS issued in May, stating that NIL collectives should not be entitled to, or at least most NIL collectives should not be entitled to 501c3 status, which permits donations to be tax deductible. So this bill amends the IRS code to disallow those tax deductions for any contribution, except those directly to schools and colleges, for any portion of which is used to compensate one or more student athletes for use of their NIL by reason of their status as student athletes. Again, pretty straightforward. One thing I will highlight about this is the way it is currently written. This is not narrowly tailored only towards NIL collectives. This would include other charitable organizations that receive those individual contributions that may go towards student athletes. And so that is a broadness that, in my personal opinion, I'm sure there are individuals that may have differing opinions, maybe a little bit too broad. I could see a world where, real quickly, just a hypothetical of, maybe a local blood bank wants to pay a student athlete to help get the word out on donations of blood. Under this, as it's currently written, that may not be tax deductible, those contributions. I'm not exactly sure that is what this is meant to get at, but again, I'm sure there are arguments on the other side.
Thank you, Brandon. Second up, meet Jama Meyer, of counsel at Simpson, Thatcher, and Bartlett, and a visiting clinical professor of sports law at Indiana University. Also just won a landmark high school Title IX case in Hawaii, I'll add. Jama will review the Gender Equity Bill, Women in NCAA Sports Act, being considered by the 108th Congress. There are additional bills addressing the issue of transgender athletes in women's sports, but we will not address those today, as both bills are stalled at partisan extremes with no likelihood of resolution until after the 2024 election or a Supreme Court decision. We want you to be aware that these would have an impact on college sports, but are much broader bills that apply to all of sports. Jama.
Thank you, Julie, and thank you to the Drake Group for putting on this incredible and comprehensive webinar on current events. I'm going to discuss one of the few bills that has bipartisan support. The WINS Act has sponsors from New Jersey, a Democrat, Mickey Sherrill, and from Republican from Florida, Maria Salazar. The act would establish a 16-person commission to do a comprehensive study of the NCAA and how it approaches gender equity, in response to the championships, but also its rules and its constitution. The background of this is something that I'm sure most of you will remember. In 21, Sedona Prince went viral with a video that she posted that showed horribly gross inequities between the men's and the women's championship basketball tournaments. She showed that the women only had a few freestanding weights, while the men had an extensive weight room. It turns out there were many more inequities, whether it was the transportation, the food, the courts, the TV coverage, even the COVID tests were different. So there was a lot of outrage, and people stood up in Congress and are aware of this and are now going to, hopefully, if this bill passes, look at this comprehensively. The NCAA has tried to, on its own, look very deeply as to what the inequities are. The lawyers have been busy. Immediately after being totally humiliated, the NCAA hired the Kaplan report to do a comprehensive study. And then more recently, Rice Lewis was hired to determine what of the recommendations that the Kaplan-Lewis, or the Kaplan's report recommended have been implemented. So I think this is really important, and the commission can use what the NCAA has studied to date to get a head start. For me, though, the bigger question here is, should the NCAA be subjected to Title IX or under the jurisdiction of Title IX? This is an ongoing question. The courts have found that a number of state athletic associations are under the jurisdiction of Title IX under a controlling authority theory, that the schools and the association are so entwined that there's no reason for the association not to be also responsible under Title IX. So this is an ongoing situation with respect to whether the NCAA should be held responsible for Title IX violations. And I know there are certainly lawyers out there looking for the perfect plaintiff to bring that case.
Thank you, Jema. Now we get to the 7 NIL bills, which have either been filed or announced and issued as drafts offered for comment. Representatives of the NCAA, prominent athletic conferences, and athletics administrators have been pacing the halls of Congress, asking for federal laws that would negate the patchwork of state laws that gave college athletes name, image, and likeness rights. NIL compensation is a good thing for athletes, but an unintended consequence was the subsequent creation of NIL collectives, organizations of boosters and fans that collect money to provide NIL compensation to athletes for the purpose of giving that school a recruiting advantage. New coin for the college athletics arms race. The NIL space also provides an opportunity for unscrupulous agents to take advantage of young athletes with little or no experience in monetizing their publicity and endorsement rights. Congress finally appears to be paying attention, and a number of bills even reflect bipartisan support. Our next 3 panelists will give you a sense of all the ideas that are currently on the table for federal legislation. First up, meet Dr. Donna Lopiano, President, Sports Management Resources, and current President of the Drake Group. Donna will review the first 3 NIL bills being considered by the 108th Congress. Donna?
Hey, thanks, Jules. So all 3 of my bills preempt conflicting state laws and protect athletes' rights to outside employment. So I'm not going to repeat that for each. The first one is from Senator Booker, a Democrat from New Jersey, Senator Blumenthal, Democrat from Connecticut, my state, Senator Moran, a Republican from Kansas. So it's a bipartisan draft of a bill called the Collegiate Athletics Protection and Compensation Act of 2023. It would establish a new federally chartered non-governmental organization called the Collegiate Athletics Corporation, the CAC. The CAC would enforce the act over agents, over institutions, conferences, and the NCAA, It would have subpoena power to do so, very helpful when investigating inducement allegations. It would be responsible for solving athlete contract disputes. It would maintain a comprehensive searchable public database containing each institution's required annual website report. And this database, by virtue of the act, would have to contain everything from tracking the number and value of NIL agreements to graduation rates to the hours spent by the typical athlete in athletics at that institution. It is, by design, the most comprehensive athletes' rights bill among the 7. Institutions, for example, would be required to give legally binding full disclosure prior to enrollment on costs paid for by the institution versus those that have to be paid for by the athlete. It would establish a one-time transfer without penalty rule for athletes who wanted to change schools, but unlimited transfers without penalty, without.
Looks like we may have a Donna freeze there. Okay. In the meantime, we will move on to, unless Donna comes back momentarily, to our labor law expert, attorney Rick Karcher, professor in the sport management program at Eastern Michigan University, and a member of the Drake Advisory Council. Rick, oh, you're back. Okay, we'll pick back up with you, Donna. We have a bad connection here. Okay, taking back up with attorney Rick Karcher. Rick will review the next 2 NIL bills being considered by the 108th Congress. You're on mute, Rick.
I'm sorry. Thanks, Julie. The first bill I'm going to talk about is one from Ted Cruz. It's an untitled bill. It's listed as a discussion draft. I'm going to point out 7 items that I think are important in the bill. The first one is that institutions, conferences, and the NCAA shall not restrict the ability of athletes to obtain agents or enter into NIL agreements, but they may restrict eligibility if the agreement violates student athletes' code of conduct or reasonably impacts the reputation or public image of the entity or conflicts with an existing contract of the athlete's institution. None of those are defined as in terms of what that means, what those things mean. So I guess it's left up to the institution and conference and association to just decide those things. But the key question here in my mind is whether, or from the bill, is whether NIL deals can be entered with boosters, because in brackets throughout the bill, there's this one point, anytime they talk about boosters, it's in brackets. So they're leaving open the possibility that if they decide to exclude boosters, they'll do that, so that athletes can't enter into deals with boosters. But to the extent they can, maybe then the rest of this still applies to boosters. Athletes are required, the second item is athletes are required to disclose the terms of their agreements to the institution. The third item is that athlete NIL contracts are void if they don't satisfy certain requirements. And it gives the FTC jurisdiction to enforce those requirements. Fourth item is what they're calling a fair market value section of the bill, which states that each institution shall disclose to the NCAA in an anonymized manner the following data with respect to these agreements. In other words, a description of the services rendered and the amount of compensation to be provided thereunder. And then there's also a database that must be maintained. It says the NCAA shall, and that shall language actually conflicts with another section of the bill, which makes it permissive for the NCAA to do. So that's a conflict within the bill itself. But it says the NCAA shall, in this section, use the anonymized data to establish and maintain a publicly accessible, searchable database for student athletes and their agents to estimate the fair market value for name, image, and likeness agreements. Okay, and then the fifth item is that institutions and the NCAA and the conferences get blanket immunity from lawsuit. Basically, it says that no institution or conference or the NCAA is going to be in violation of any law, federal or state law. Could drive a truck through it, basically, in terms of what the blanket immunity covers. And then sixth, there's preemption of state law. And number 7, last but not least, non-employee status. It says that regardless of what state and other federal law might say, college athletes are not employees, which raises the question, well, I don't know, what if there's a conflict between the National Labor Relations Act, which is a federal law, and this statute? I don't know the answer, but that could be litigated. So the second bill that I'm covering is Lindsey Graham's bill. I'm going to cover 5 items in this one. All right, so the first one is, it says, with respect to a student athlete who may enter or who has entered into a name, image, or likeness agreement, and by definition, an agreement actually excludes transactions with boosters and collectives. Really interesting. That's not even in brackets. It says an institution may not retaliate against the student athlete. May not. So it's not a requirement. May not retaliate. Well, may not. Yeah, we'll interpret that to mean that they shall not, I guess, shall not retaliate against a student athlete for considering or having entered into such an agreement by limiting the playing time of the athlete or making adverse changes to their scholarships, which they don't do in any event ever, with regards to some sort of NCAA violation. All right, so the second item would be, says an institution may prohibit. So that's discretionary. May prohibit student athletes enrolled in the institution from entering into name, image, and likeness agreements with entities in a particular industry if applicable state law prohibits all institutions located in the state from entering into agreements with those entities. I don't know what that's referring to, but and secondly, and such a name, image, and likeness agreement would violate the student code of conduct of the institution. And then it says that they may prohibit a student athlete also from carrying out an activity that pursuant to a name, image, or likeness agreement that would conflict with a sponsorship agreement of the institution or the team of a student athlete. And then there's a public disclosure requirement. It says that no later than January 1st of each year, each institution shall make available to the public a description of any of these 2 prohibitions I just mentioned. In other words, what entities student athletes can't have agreements with. So they got to disclose that so that athletes know that. Third item is that there's a clearinghouse established. Institutions and conferences may, it's not required, may establish a clearinghouse for the purpose of regulating name, image, and likeness agreements. And it says that this clearinghouse shall, if they decide to create a clearinghouse, that it shall monitor compliance with the Act, shall establish and enforce penalties for violations of the Act, and provide to student athletes educational information with respect to legal and tax complications. It also says that this clearinghouse shall provide to the FTC, the DOJ, the Attorney General of the state, on request, basically provide a record of everything that's in the clearinghouse. And thirdly, with regards to this clearinghouse, if it's created, that they shall carry out enforcement actions for any violation, and it gives them broad discretion to do whatever they want. Fine, levy fines, impose penalties, do whatever. Okay, fourth item, I got 2 more. Fourth item is an antitrust exemption related to this. If the institutions and conferences decide to create this clearinghouse, they would be exempt. Its actions would be exempt from antitrust law. And last but not least, number 5 is a rule of construction. It says nothing in this act may be construed to limit the ability of an institution, conference or athletic association to prohibit a third party from providing to a student athlete a recruiting inducement or a compensation for participation in intercollegiate athletics. Note though, don't interpret that to mean that that's an exemption from liability. Okay, they're not saying that. They're saying this is a rule of construction. Okay, so that's not the same as saying that there's exemption from liability if somebody were to challenge a institution, not giving athletes compensation.
Thank you, Rick. We're going to circle back to Donna on the 3 bills to give an abbreviated summary of those bills, and hopefully she won't cut out.
Hopefully he's right. Okay, just to finish up on the Blumenthal, Booker, Moran bill. Notably, that bill is the only bill among the 7 that would have anything to do with academics. An institution would not be permitted to discourage athletes' choice of course or major or retaliate based on that choice. And another even more important provision, that all institutions would be mandated to provide financial aid until graduation instead of the current 1-year agreements. And the last piece of that provision was that the NCAA would be held responsible for equally treating male and female athletes. The second bill to talk about is also a bipartisan bill. Senator Joe Manchin and Senator Tommy Tuberville from West Virginia and Alabama, respectively. They've proposed the Protecting Athletes, Schools, and Sports Act of 2023. And this is an interesting one in terms of construction. The act would require all agents, all third parties, collectives, boosters, everybody to register and disclose NIL representation and employment agreements to the Federal Trade Commission. However, the Federal Trade Commission would be charged with overseeing the NCAA to make sure that the NCAA enforces the act. So the NCAA would have the responsibility to govern and enforce all of these NIL agreements, the institutions and third parties agreements, compliance with the act, and to resolve all the athlete complaints and disputes. The act would not only preempt state laws that conflict with the act, it would preempt any state law inconsistent with Title IX, including laws that provide for the payment of college athletes from any share of annual revenues derived or generated by a particular sports program. So there couldn't be no revenue sharing based on basketball, football, for instance. The act would also only protect NIL rights during enrollment. The athlete could only enter into an NIL contract if they're enrolled, and the agreement could not extend beyond enrollment. It also has very strong written contract requirements, also allows the athlete to choose arbitration instead of the questionable NCAA adjudication process. And real notably, the athlete would almost totally eliminate athlete transfer eligibility rights. The transfer athlete would be immediately ineligible to play sports at their new institution unless the athlete completed 3 years of eligibility, unless a family member dies or is diagnosed with a terminal illness, or, big exception, his primary position coach voluntarily or involuntarily leaves the institution. We assume this is a football provision from Tommy Tuberville. But it has very strong athlete medical benefits, not as strong as the Booker-Blumenthal-Moran bill, in that it only mandates coverage through 4 years following the completion of eligibility and has no long-term coverage at all. Lots of loopholes, too, for collectives. The last bill is by Representative Gus Bilirakis from Florida, and it's called the FAIR College Sports Act, Fairness, Accountability, and Integrity in Representation of College Sports Act. It would establish, like Booker, Blumenthal, and Moran's bill, an outside entity called the United States Intercollegiate Athletics Committee. And this would have responsibility for enforcing the act. But some real twists on the previous bill that I explained. The organization would have to operate a tip line, public tip line. Agents would be required to register, but could not execute a representation agreement until 45 days after an athlete enrolls. Think about that for a second. The athlete wouldn't be able to do NILs until after enrollment, would not be able to get a representative, an agent, until then. And then another interesting provision would be third parties and collectives would have to register, and they would have to issue, give an affidavit of non-inducement. They would have to provide copies of NIL agreements within 30 days under penalty of perjury. They would have to make a monthly disclosure of compensation amounts and descriptions of work for which that compensation was paid. And this is a kicker. For collectives only, collectives would have to provide the name and contact information of all donors to the collective, and whether any of those individuals had ever experienced bankruptcy, filed for bankruptcy, been convicted of fraud, or caused an athlete or an institution to be sanctioned. An interesting provision. Like the Manchin-Tuberville bill, the act would specify the FTC as the enforcer, but it would have a twist to it that if any athlete or any collective or agent failed to register, they would automatically be in violation, and the FTC would impose penalties. And then there are three notable restrictions on athletes' rights: that no NIL agreements would be permitted until the athlete is enrolled for at least 90 days. No NIL agreement could include any compensation or incentive for on-the-field performance. And the NIL agreement couldn't conflict with any of the institution's sponsorship agreements. And maybe the three biggies here, which are provisions that protect institutional interests. One, that institutions, conferences, and national associations would be prohibited from paying athletes for their licensing or publicity rights. Read that. Prohibit revenue sharing from television media rights agreements of institutions. The second one is outside NIL agreements have to meet a fair market value standard, something that currently exists in NCAA rules for outside employment. And last, national associations and conferences would receive an implicit antitrust exemption to establish rules that could render athletes ineligible who receive those payments, or to withhold distributions from institutions who give those payments in violation of the act.
Thank you, Donna. And last up, but not least, meet Dr. David Ridpath, Professor of Sports Business at Ohio University, who is a past president and current board member of the Drake Group. Dave will review the last three NIL bills being considered by the 118th.
Thanks, Julie. Really appreciate the opportunity to be on. I want to start actually with a very easy one of the three bills that I have. One that probably actually has a real chance of being passed, maybe even before next election. And it's a bipartisan bill that Pete Ricketts of Nebraska, Republican, and Richard Blumenthal, who we've mentioned, who's been involved in other bills, are co-sponsoring. And it's actually giving international athletes the ability to earn money off their name, image, and likeness that would actually provide a waiver to the provisions that they're under right now with the immigration rules and regulations with regards to employment. I think across the board, that has been something that has been talked about as something that needs to be done. And it's even mentioned in one of the other bills that I'm going to talk about right now. Really, that bill, that's really all it is. It's a standalone issue. I think it's one that will likely be passed, whether as part of a larger bill or this one as a standalone. The first one, I should say, the second one I want to talk about that's certainly much more in detail, also has the international provision in it that I just mentioned, but is probably, in my view, and the other panelists can agree or disagree, but probably the most pro-athlete, I would say, bill out there. And it's by Senator Chris Murphy, who has certainly been an advocate for college athletes' rights now for many years. And then also a Congresswoman, Lori Trahan, who is a former Division I athlete. So I think certainly this bill has a lot of stuff in it that I think from a Drake Group perspective and from others who do support athletes' rights has a lot of good things. And like Rick, I'm just going to hit on a few of the highlights, 5 or 6 of them that I think are really, really important with the bill. Similar to what others have been said, that institutions have to obtain licenses from athletes for the use of their NILs, meaning the athletes would actually enter into an agreement. But it would also prohibit institutions from prohibiting the athletes from entering into really any type of NIL agreement, meaning that there's no restriction on tobacco, cannabis, alcohol, anything like that, unless, and this is the only bill that really, at least to my knowledge, that mentioned this, unless it's collectively bargained with the athletes directly. And I think that is maybe a caveat to something that Senator Murphy has talked about, potentially future athlete unionization or collective bargaining on some of these issues to help provide some antitrust protection. It also prohibits institutions from trying to collude to lower or prevent NIL payments, prohibits institutions from restricting the ability of the athletes to get legal and agent representation. There's no time limits or anything like on some of the other bills. Like some of the other bills mentioned, though, it does require collectives to register with the FTC. So the FTC does have an oversight responsibility within this. And what this primarily is for, similar to what Donna was talking about, Rick talking about, is more of a data gathering of what the NIL collectives are doing, what types of agreements the athletes are entering into, so there can be some type of national database to establish fair market value. Other things that are added in, as I mentioned, the international aspect also gives athletes some strong private rights of action to be able to sue the NCAA for violations of antitrust, and certainly in things for eligibility restrictions and those types of things. And probably the big one is there's no prohibition on the use of NILs as inducements. I think that this bill at least recognizes that that would be a very difficult one to enforce. I know some of the other bills mentioned that there's affidavits of non-inducements not being able to enter into NILs after enrollment, until after enrollment, things like that. But this one, again, is very pro-athlete with very few restrictions. The last one is from 2 representatives from my state, Mike Carey and Greg Lensman, both in the House, from Ohio. And they do put, I'd say, many, many more restrictions on the athlete, much more oversight from the FTC. It requires the FTC to be an investigatory authority if there's anything that are violations of this act. The big one, NIL agreements cannot be entered into until the athlete enrolls in college. Boosters may not be involved in any way, as it is right now, technically by NCAA rules. Boosters cannot be involved in any way, directly or indirectly, to provide funds or inducements or anything of value to get athletes to enroll at a specific school. It does also say, though, that institutions cannot prohibit athletes from entering into NIL agreements or penalize students' eligibility for participation related to their involvement in NILs. Then the FTC, going back, similar to what the Murphy bill said and some of the other bills mentioned, is that the FTC would actually have that be a clearinghouse for NIL agreements that are greater than $500, and that the institution and the individual would notify the FTC that database would then be public, and that there would be a report that would be a yearly report that the FTC would put out with regards to that. And also that institutions can prohibit athletes from wearing certain clothing and gear, institutional marks, during athletic competitions and events that they're participating in. So, if the athlete has another shoe deal, but the institution has a shoe deal, they would have to abide with the institutional shoe deal. Maybe the two biggest things I should say from this bill is that there is a antitrust exemption provided in this bill that that institutions in the NCAA would be protected from being sued under the Sherman Act. From a Drake Group perspective, we think that that's too broad of an antitrust exemption. We think it should be more conditional on managing costs and also medical protections for the athlete. And then it also does establish an athletic organization commission for a 3-year period to basically report to Congress on how FTC oversight is going on, how NILs are working, how are inducements, have they been eliminated, those types of things, but also establishes an independent dispute resolution process for the athlete. And they have to produce an annual report for those 3 years. So those are really the highlights of all those bills. There's some more detail that we can get into, but for me, Julie, that wraps up my portion.
Thank you, and I'm sure we will. Big thanks to our panelists for mostly meeting the time challenges and purposes of the 15 bills on the congressional plate. Now on to the big issues to be solved. And first we'll address inducements. None of the NIL bills define inducements, but all NIL bills, except one specifically, prohibit the offer of NIL as inducements for college athletes to attend or remain at an institution. I'll ask Rick our first question. Why are inducements such a complicated issue to tackle when it comes to outside NIL compensation?
Yeah, thanks. Good question. I think, boosters booster donations have always been tied to inducements, as we know. I can think back to, whether you're talking about, suitcases full of cash, or you're talking about, the Johnny Manziel case, and 10 years ago when he, sued a t-shirt maker for using his name, Johnny Football t-shirts. He sued, and he settled the case because, rightfully so, the shirt maker used his name and image, his name and likeness without compensating him, which is a violation of he had a trademark with it, but also would violate his right of publicity. But I think if you look back to that case 10 years ago, I recall vividly what the discussion was, and the NCAA was saying, well, we're concerned about a booster loophole, with this type of transaction. In other words, the settlement was reached. They said Johnny Manziel can keep this money, of course, because it's his property that was stolen. And so, he's just being compensated for the theft of his property. So the NCAA couldn't prevent him from keeping that money. But they were clarified that, there won't be a booster loophole here. It's going to be closed. The lawsuit, is going to close any booster loophole here. And, it just is, it makes you think about the issue back then, which is what we're struggling with today. A booster owned company, how do you determine whether it's an inducement or not? And so the narrative on this stuff today is that this is just impossible to determine fair market value, right? Of somebody's endorsement, and trying to determine whether the amount that they're getting is in excess of what the true value is of that particular endorsement. My response to that is really 3 things. One is, what's lost in this whole discussion always is the NCAA's governance process, which is based on institutional control. And so this is nothing new, whether you're talking about 50 years ago with suitcases full of cash, or you're talking about, some athlete that received, some money beyond his or her reasonable and necessary expenses for, in playing on a club team overseas. The institution is the first one under this system that is supposed to be governing these things, these issues. And they're supposed to withhold the athlete from competition and then go through the reinstatement process. We've seemed to have lost sight of that, or willing to pass on this and say, it's somebody else's problem to deal with. Somebody has to deal with this because these institutions aren't exercising their institutional control. It's got to be either the NCAA or Congress or somebody. The second thing I want to say is about this is that the NCAA reinstatement committee on these issues has always reviewed transactions and made determinations whether there's an excess benefit that was received in a given transaction. Okay. And then, so they're capable of doing it. Okay. They've done it before in a lot of different situations. They could do it again. And then thirdly, the way you could look at endorsement deals would be that are involved with boosters. You could review those similar to interested party or related party transactions. So those types of transactions are typically evaluated by the IRS or by taxpayers by looking at comparable transactions entered into. In this case, it would be looking at comparable transactions that have been entered into with non-booster affiliated companies. So when I say comparable transactions, you'd be looking at, the type of athlete involved, sport involved, skill level involved, level of institution that's involved, and then looking at what other, types of compensation was given in regards to the type of activity that the athlete was doing, in connection with that non-booster affiliated company.
Thank you, Rick.
Yeah.
Does anyone else like to say anything about determining fair market value when NILs are being offered on the basis of the value to the institution?
Well, I just think too, and Rick, you can comment on this, but I just think, again, we're still only a couple of years into this. I think we have to wait for the market, to level out. And I think we're going to see maybe some, if you will, more sanity and balance coming to the market eventually. I think we're seeing it already. But I think it's hard to determine fair market value at this point in time. I don't know if there is a way to ever do that. But I think we also just have to give it time.
Well, we have lots of transactions, right, David? I mean, there are thousands of NIL transactions that have been entered into already. I mean, I guess I don't know why it would be difficult to take the body of those transactions and do that. I mean, that's what people do when they're determining these things. I think there's enough there, I think, is what I'm saying already. After 2 years, I think we got enough transactions to be able to do it. Not we, I mean, the NCAA.
Hey, Rick, here's a question on that. Can you, just for the sake of our audience and the public, distinguish between what NIL collectives are doing now in terms of how they are valuing the NIL transaction and a disinterested booster in terms of the relationship between the institution's roster value and what might be available in the open market? The artificial market versus the open market. Why are we dealing with such an artificial market?
No, the answer to that's simple, because they want the player, and the question is, how much are they willing to pay to possibly get the athlete to come to their school? I mean, that is undeterminable. I mean, that's for them to determine. The question is, what's the difference between what they're paying on a particular transaction and what a non-booster affiliated company would pay, or a disinterested company is paying? And that data is there. It's all out there. I mean, everybody's keeping track of it. On3, all these people, they got all the transactions, thousands of them. I mean, this is not something that the NCAA can't get their hands on.
I would suggest, though, that we don't really know what's going on out there. Yes, we know a lot, and we've got a lot of entities trying to acquire that information, like On3. But because we do not have a third-party administrator or, a publicly available database like some of these bills suggest we should have, we really don't know how much money is going and is involved and to whom. So I think that's the first step, is having all of the information. Then secondly, it needs to be analyzed. And I do think economists tell me that there is a way to come up with a fair market value standard. And once we are able to do that, then you will be able to pretty readily see and determine what's an inducement and what's not. So,
Shema, do you mean what we don't have available so much? It would be the booster transactions and what money is being paid to athletes, because I think I agree with you about. I think though the non-booster transactions that are what I would call let's just for purposes of the discussion call it legitimate NIL, meaning right the true endorsement type of transaction where the entity or person is getting a return on their investment, and they've decided in an arm's length transaction, a disinterested party and what that's worth in terms of a return on investment to get that endorsement. Those transactions, I think that, do you agree that data is available pretty much from different sources?
Well, it's from a lot of different sources. Depending on the state, the athlete doesn't even have to inform their own institutions what the deals are. And I know schools don't even know what their own athletes are receiving with respect to NILs. So I think there's a lot of unknown out there. And if we had a uniform law, a federal law, or the NCAA were able to get around the antitrust problems and have a third-party administrator or a requirement that all of these contracts be submitted to a central source, then we would know. But right now we don't. Yes, we know that probably there are only 2 women in the top 20 NIL earners. You know, we do have much more information than we had a few years ago, but I think it's really incomplete still.
I think of certain anecdotal stories we've heard about the high school athlete Jaden Rashada being recruited clearly with a $10 million offer, which the money wasn't ever there. And Ohio State football coach Ryan Day putting out a call to the business community that he needs 13 to 14 million to fill his roster. So the anecdotal stories are interesting, but thank you. We're gonna, unless anyone else wants to chime in on that issue, we are going to move on to the next topic of NCAA enforcement. And I'll look to Brandon first and then Dave with your enforcement expertise. Do you think the Kustoff NCAA Accountability Act's due process mandate, coupled with proposals suggested by some of the NIL bills, allowing the NCAA to request subpoena power from an independent NIL agency or the Federal Trade Commission, will help in determining the probability of inducements having been offered by third parties? Brandon.
So I do think that it would help to be a little bit more effective in this space. I think just from the standpoint of more standardization, the expectations of the information that we're able to obtain for investigations, other aspects of the enforcement apparatus, I do think that there is the potential there for it to be more effective and to help us in the inducement space. I personally, though, when it comes to subpoenas, I do have a little bit of uneasiness personally, and I know I am, on one side of this, and there are arguments on the opposite side. I do think the use of subpoenas in this space has a level of, I'm trying to articulate this the right way. We're dealing with rules, regulations within the NCAA space that our institutions, our coaches, our athletic directors have come up with. Bringing in subpoenas, in my opinion, can have, it's a little heavy-handed, in my opinion. I think there needs to be a mechanism to get this information, to inform cooperation and things of that nature. But I do wonder if subpoenas are the appropriate mechanism to do that. I know Dave has some views on this issue, and I'll kick it to you. But that is something where I like the due process. I like the mechanisms to compel the information. But I do wonder whether or not subpoenas are the appropriate mechanism for that.
Yeah, and I don't really completely disagree, Brandon. I always come at this with, as opposed to what exactly. So is it what is the best way? And when you're talking, and I agree, you're talking about what should not be as maybe as complicated as it is. These are rules that are theoretically agreed on by the membership, and everyone's agreed to abide by. But yet this has become such a punitive system that has ruined a lot of people's lives and reputations without, again, proper due process. And then also with sometimes the information being very suspect that the NCAA gets, and oftentimes relying on really less than reliable people. It was only, again, it's been a few years now where the NCAA was allowed to use secret witnesses, right? So for me, the big thing is subpoena power is one thing, and I think that there are some merits to it. I also see the negatives. But the other things that have to be added to it, right, is you have to have basic due process, right? The right to see all evidence against you, the right to confront and cross-examine your accusers, the right to be heard in front of a jury of your peers, open hearings, all those things that I think would make the NCAA process much, much better. The IARP, the Independent Accountability Resolution Process, was a very poor, misguided attempt at trying to do that. And, you know, I thought that maybe their heart was in the right place when thinking about it. But again, it has to be something, and I'm not even saying our judicial process, normal judicial process, is perfect, but it is far and away better and more fair for somebody like me who's gone through this process and just been excoriated for not having anything to do with NCAA violations, but being made to take the brunt of those just because the institution and the NCAA, by extension, want to keep the money machine going and protect certain people. I'm not saying that doesn't go on in the real world, so to speak, but I do think there's many, many more ways to make enforcement and infractions better, even to the extent of, I would agree with you on this, Brandon. I would not want to give subpoena power to some of the investigators we have now. With all due respect to them as people, they're poorly trained. In many ways, have not zero experience in college athletics. Their backgrounds are suspect. And those are some that I don't want to give subpoena power to because they're not experienced enough or seasoned enough investigators to be able to handle such, you know, a very high profile, sensitive case. And oftentimes they want to just close the book on investigations because they are overworked, underpaid, all those other things. So I think that the whole process needs to be overhauled. Subpoena power could be a part of that.
I certainly agree with you on the idea that the process needs to be overhauled. It's not working as it is. Yeah, it's that one subpoena power piece that I'm stuck on.
I appreciate both of your concerns about that, and it certainly can be misused. But I think that the NCAA does need, if it's going to be still have authority to enforce inducements, more power to get to texts and telephone calls, etc., of third parties. That's where the evidence is, as we know from conspiracies. And without subpoena power, that they're missing a lot of crucial evidence, potentially.
And not have to rely on random tweets, Jema, to follow up on.
The Cavender twins social media picture.
Right. Anything else to add to that? Anyone? Okay, we'll move on to the next issue, which is antitrust. So I'm going to look to Jema, and how do antitrust provisions play into NIL bills? Wide open question.
Yeah, it is a broad question, and we've touched a little bit upon the antitrust issues, but I think the key question here is, should there be a limit as to what the amount of monetization for NILs can be? And the reason you would have a limit is to trigger this question more easily of determining what are inducements. But right now, the NCAA cannot set rules having limits. We saw this, they studied, the NCAA had committees that studied NIL monetization, had suggested or come up with a number of guidelines, including a fair market value standard. And DOJ, right after the Alston case, hopped on this immediately, came running to the NCAA immediately and said, you're going to be potentially subject to an antitrust investigation, if not another antitrust lawsuit, if you impose such limits. So to the extent we think that there should be limits on this compensation, and have a justification for that limit, a justification like we don't want inducements or we don't want a real pay-for-play system, whatever it may be, then you need an antitrust exemption that is limited to that issue. And I would even go so far as to say that arguably the current rule with respect to outside employment that the NCAA has that limits compensation to market rates commensurate with the local, market, has the same problem. There are so many NCAA rules now that arguably have antitrust problems. And as we know, the NCAA has spent an enormous amount of time and effort trying to defend against antitrust cases. And I think antitrust cases have brought a lot of additional benefits to athletes. They've been very positive in a lot of ways, but there's got to be a more effective and efficient way to set limits in sports by the NCAA.
Dana, are you saying that at risk now are things we accept are unchallengeable by the NCAA, like their current limits on numbers of coaches or limiting scholarships by sport? Are those at risk too? Is it just that Pandora's box has opened up with the interest of antitrust attorneys?
It's yes, but it's not because of the interest. It's because of the way the law has evolved. I mean, it's early on, it was generally viewed that the NCAA almost had an antitrust exemption. And then the NCAA was given sort of this quick look analysis with the presumption being that their rules were legal. But the law has evolved greatly with respect to this. And now the NCAA rules are subject to a full rule of reason analysis where the NCAA must justify its reasons for rules that have limits that impact commercial. I just was looking at reading yesterday on X that there are some professors now that are saying that the NCAA rules with respect to in-person scouting may be subject to the antitrust rules. This was raised in the context of the controversy regarding Michigan and the signal stealing. Anything that has a commercial impact could be subject to the antitrust laws. Think about it in the context if you have Coke and Pepsi doing these things. Would that be permitted under the antitrust laws? No. And so, why is sports different?
Jema,
I'm sorry, go ahead.
Jema, the NCAA, its antitrust law is part of its business. Fighting antitrust law is basically it's part of their business. That's what it's been that way forever. This is a sport league, and it's a sporting league that has numerous conferences and institutions. Sporting leagues at the professional level, okay, deal with antitrust law. It's the nature of the beast. And this rule book has numerous restrictions. It is going to be, many things are going to be challenged, have been challenged, and will be in the future. Here's where we are today with antitrust law, and specifically college athlete compensation. Today, we have a Supreme Court ruling and a federal court of appeals ruling in the Ninth Circuit that has made it crystal clear that there's a distinction between professional level payments and education-based cash payments. What we got from the Alston case, even though it's subject to the rule of reason, can basically right now compensation that's professional level cash-based payment, with regards to these education-based payments of up to $59.80 per year. There's also language in the Supreme Court's ruling that says that, the only reason this $59.80 number was established at the district court level and then carried on through the Ninth Circuit and up to the Supreme Court is because the NCAA permits $59.80 in value of athletic-based awards valued at $59.80 per year. They permit that. So if they permit that, then you have to be able to permit 5980 in education-based cash payments, meaning the NCAA could do away with the athletic-based cash awards valued at 5980 right now, do away with that, and take the position that you're not even allowed to give education-based cash.
I apologize because I missed some of what you've had to say, but
under
I
that
think
rule,
a couple points that professional
education-based awards under the Alston ruling.
Rick, you're cutting out. Sorry, go ahead, Gemma.
That professional.
Yeah, I see that. Can you hear me now?
Professional sports have an antitrust exemption via the non-statutory, labor law exemption. That's why there are salary caps. That's why there are excise taxes, agreements that the teams can come together and agree to those limits. And interestingly enough, you mentioned the Alston case and you mentioned the Ninth Circuit. I think it actually was in O'Bannon, and Wilkin also, the Northern District of California judge who has been so involved in all these antitrust cases. They all have said, maybe this is an issue that Congress has to deal with because the antitrust laws are going to, do these whack-a-mole approaches and won't be able to holistically look at what is best. These limits violate frequently the antitrust laws, but we need Congress to come in and better determine what is an appropriate limit.
Can I jump in? Go ahead, John.
Just as a hypothetical, right? Let's assume we agree that there's a need for a limited conditional antitrust exemption. Write it, Jema. What would it be for? That would allow the institution to do its job to govern within an educational sport context. But can you just conceptually shape it or just throw bullets out? What would be the carve-outs that we could trust?
Well, most importantly, if a limit advances the academic mission of a school, then it should be, I think, permitted. So it focuses in on the educational benefits in college sports.
What about cost?
Also, health and safety is very important. That would be costs in terms of salary caps for coaches. Is that what you're thinking about? I mean,
or cost generally for lavish facilities or salary caps aggregated, not necessarily for individuals, right? I mean, it seems like we're in a cost dilemma for higher education where tremendous subsidies are being used by athletic programs to keep everything afloat with no guardrails. I mean, somebody's got to do the guardrails, and Congress is not good at micromanaging. The NCAA can do guardrails if it had cost permissiveness in terms of antitrust exemptions.
Correct. So I'm not sure I understand your question, but yes, to the extent that these expenses, whether they're facilities, lavish facility spending, excessive coaches' salaries, excessive buyouts, whatever they are, they do arguably harm the academic mission because it's taking money away from what might otherwise go to academics, or taking harm away from students because it's their student fees that are paying for this, or intra school subsidies or state subsidies. It's all arguable. You need it depends on the facts and the circumstances and the proof. But absolutely, I think there should be some antitrust exemptions for controlling excessive spending, especially in a nonprofit organization whose mission is focused on education.
And is the NCAA arguing that? Is the NCAA arguing that in House or any of these huge payout situations that it's hurting the larger education institution?
I think indirectly. I mean, House, we really haven't seen, it hasn't been decided. It hasn't even been a summary judgment motion. But that certainly is one of the arguments. And also it's to protect the product. You know, if we don't have a demarcation between professional and college sports, because there's so many, the money is the same, then what will happen to college sports? And then there are a number of justifications that the NCAA is arguing.
Thank you. And Gemma, we certainly hear many say, or sometimes rant, that we don't need Congress involved. They shouldn't be involved. Let the NCAA figure it out. Certainly the NCAA had a long time to figure out NIL, and it was forced upon them. But would you say overall then it's accurate or inaccurate to say in order to effectively exercise oversight, they would need some congressional help to a path forward?
Well, it would have to, but we don't want Congress micromanaging, right? That's the last thing we need. They don't have the capability to do that or the expertise, but there are limited areas, let's say, like how much one would pay athletes or how much one would pay coaches, that the NCAA cannot control unless they have an antitrust exemption.
Thank you. We certainly don't hear enough in the context, other nuances like 20 to 24 schools operate in the black every year, or being upside down in facilities. We're gonna have to move forward to the next issue on NIL collectives and gender equity. And I'll look to Gemma and then Donna, but why are NIL collectives causing such a Title IX concern?
I'll let Donna recite some of the figures about, collectives and how much of their money is going to women.
I think everybody's probably seen the guesstimates of, what's happening out there, right? Close to 90% of all of the value of NIL collectives are being collected by men, primarily in basketball and football. And the examples of women are primarily anecdotal. And you just look at what's happened recently in terms of, gee, I wish I had a Ram truck, even for a 6-month lease with, all my insurance paid. Are they red? Are they all red? Maybe not. Maybe not. No, but seriously, that we have been on the case of the Office of Civil Rights in terms of just not being near the starting gate and applying existing guidance, Title IX guidance, to collectives. And it's very maddening in that regard. So
certainly
I think
that loophole, right? So,
when you consider the fact that Title IX has been around for 50 years, when you consider the fact that institutions have been ignoring their publicity and promotional rights obligations under Title IX for 50 years, when you consider that that's what has elevated the value of male athletes for 50 years and not female athletes, and now you look at the differential of 90% male for NIL compensation, right? You understand why. It's because institutions have not elevated the visibility or the brands of women in the same way as men. So it all gets back, to equal treatment. And I'm not sure how to tackle it unless somebody has a better idea.
Yeah, I think one way to look at this too is to step back and think, well, could the school engage in this activity to the same degree of inequality? And of course, the answer is no, that the school couldn't just pay its male athletes 90% of whatever pot it puts together for paying athletes. So think of it that way. And then if the school is totally entwined with a third party, such as a collective, and that's an if, but if they are, why should the school be able to avoid its Title IX obligations by having a third party engage in that activity inequitably?
Nobody's disagreeing with that. If you are entwined, right? If you are sufficiently entwined, Title IX should apply. Otherwise, you're doing a workaround to get out of Title IX, right? The question is who's going to enforce it. And I've been saying this for quite a few years. It'd be pretty easy for the NCAA to establish a rule that says, as a condition of membership, you must be in compliance with Title IX. Every 3 years, your conference has to walk in and do a Title IX assessment. And if you're out of compliance, we'll give you a year to get back in. Otherwise, you're not eligible for postseason play, or we evict you from membership. But the NCAA refuses to, even though it has a principle based on it is the responsibility of institutions to comply with federal law, it refuses to establish rules that make sure that gender equity is realized by athletic programs.
But Donna, maybe we can go back to the beginning of our discussion in the WINS Act. So we're going to have the 16-person, hopefully a 16-person congressional committee who is going to examine this issue. And hopefully that's one proposal that they will consider.
There you go.
Thank you. We're going to put one more question up before we get to the Q&A, and any Q&A we don't get to, we will write those out for the audience. But the last question is regarding NIL and monitoring and enforcement. Is it feasible to have institutions monitor and enforce NIL rules, just like they currently enforce NCAA outside compensation rules or NCAA outside employment rules?
I mean, I can jump in on that real quick. I'm sorry, Donna. I was just going to say that, and Brandon can probably attest to this. It was tough enough before NILs to try to monitor one outside employment when that started again, and then the issues with that. Although it was something I fully supported, there were some issues with as there always has been in college athletics, as Rick alluded to, with envelopes of cash. There were always a lot of mystery jobs and things like that too. You know, going back to SMU, then also managing types of outside aid, and all those things are very, very difficult. Honestly, for me, my view is, Julie, that I don't think the institutions can do it and do it effectively unless you completely give them almost a division to be able to do that. But you do have these entities already, the On3s, the Open Doors, and others that I do think, or if one of these bills goes through kind of an FTC reporting system, third-party clearinghouse, that's much better equipped than the institutions. Honestly, in my view, I almost think the institutions should stay completely out of it, other than maybe from a reporting perspective. Trying to enforce it, I think, is a fool's errand because it wasn't a good job. They weren't doing a good job before NILs.
But David, you're referring to when it's difficult to gather evidence when it was all done under the table, so to speak, right? But now that everything is above the table or on the table, I guess, however you put it, these deals we know about them. I mean, like we're talking about them. I mean, like how many times you want, like the truck deal? I mean, like let's just pick one. I mean, like 85 players get trucks. Okay, every player gets the same $60,000. Is it 60,000 or 80,000? Oh, truck. Okay, so are you saying that they can't enforce that? I mean, they meaning the institution can't enforce that, or is it just that we don't expect them to, or we don't think they should have to?
Well, I think it's maybe a little bit of all. It's just more the resources to be able to do that, and I think it's almost more redundant in a sense. If you have the ability, if this is being reported to the FTC, or if this is being reported through another third party, that information is there. Again, a lot of these compliance offices are understaffed. They don't have the ability to investigate things. They have a lot of other things going on besides NIL transactions. I just don't think it's the best entity to do that, or unless they need to be able to have the resources to be plussed up to be able to investigate that. Because even if the information is there and transparent, Rick, if there's one violation, going in and investigating that and finding out what's going on takes a lot of time and resources, in my view.
Okay, follow-up question then. Do you agree with institutional control? Because the whole governance system, because we're talking about NIL, there's a whole Article 12 of all kinds of amateurism rules, right? The no draft rule, the no agent rule, we could go through them all. You know, the can't receive money beyond reasonable necessary expenses received from some club team and internationally. I mean, so isn't that the system though? Is institutional control? Maybe you're making an argument that, hey, come up with a different system. Institutional control isn't practical. Is that a better way to think about it? Just look at it broader and bigger and say, do away with this because it doesn't work.
I won't say that you're far off completely, Rick. Yeah, I would say it's not that I'm against the concept of institutional control. I will say that the person that is being controlled is the athlete, and they do not have a voice at the table. So any institutional control measures, I think, need to be agreed to by all actors. And the athletes don't have any ability to interact or have any voice in that process. That's why, again, we're talking about antitrust. I was going to mention this earlier. If we're looking for a lot of antitrust protection, potentially some balancing of expenses and all those other things, we need to give athletes a seat at the table, a negotiating seat at the table. Okay. And all those restrictions, if they're agreed to by everybody, Rick, I understand. But right now, the athletes do not agree to those, and they're the ones that are mostly controlled.
Well, it's interesting because when you're talking about that Accountability Act and you're talking about the due process protections for the school in the enforcement process and all that, my mind goes to, well, why aren't we talking about the due process of the athletes? And
that's what I was referring to, Rick.
But the Accountability Act that we were talking about earlier on this call, to me, the focus, if you want to go this route, and I agree with you, I'm concerned about the athletes and their due process and their say or whatever. But the reinstatement, the NCAA reinstatement process is a problem from a due process standpoint. Okay, if that's the issue that we have, then there should be something congressionally that gives athletes some protection outside of the student athlete reinstatement process. Like, for example, you could adopt the Federal Arbitration Act, all the provisions in the Federal Arbitration Act, which would provide a neutral arbitration process for athletes who are, as you say, caught up in these disputes, and they have no say or protection. I'm just saying the whole process of institutional control is that, and I don't necessarily agree with it, it's just always been this way, that the institution is responsible for enforcing its athletics in compliance with that entire rule book.
And I would say that, again, I've been one I've really been pushing systematic reforms, but looking at the Murphy bill, I mean, it definitely is saying that the athlete and others involved in the process would get due process. And that, for me, is, I'm really more on the side of the athlete. And I do think we have the ability to deal with some of our antitrust concerns if we give athletes a seat at the table. It's not that I'm against institutional control, but I think the evidence is very clear. It hasn't worked very well, to be honest with you, if you look historically, in my view.
Mm-hmm.
Okay, thank you both. We're going to get to the first Q&A question, and I will pose this, I think, to Gemma and Rich. Rick, if the National Labor Relations Board clashes with USC results in the case being declared employees, does this make all of the NIL bills non-issues?
Well, it's a little complicated. I mean, so USC is a private school. It's unclear exactly what will happen here, whether it'll apply to just USC or whether there will be some kind of joint employer application, and therefore it'll be broader. But no, I don't think it makes these NIL bills non-issues. That again, it's almost this whack-a-mole approach again, where we have, one thing will happen to one school potentially, but it doesn't mean that all, and it depends on state laws too, that all student athletes will all of a sudden be employees. So
my brief, quick comment to the question, answer to the question is, to me, it's a collective bargaining issue that's very complicated. That this case out in California with the NLRB doesn't answer. It doesn't resolve. So even if the NCAA is a joint employer, which I highly doubt that it's going to ultimately be determined to be one, for a whole variety of reasons based on NLRB precedent and Federal Court of Appeals rulings on the joint employer rule and what types of organizations it applies to, and situations that it applies to, as well as the justification for it, which is beyond. I only got 4 minutes on this webinar, so I'm going to stop on that issue. But collective bargaining could be an answer to this NIL issue for sure, absolutely. But we're not even close to getting to that point.
Next one, can you specify examples of NIL deals or values, collectives or not, involving the payment of money, which are available for public consumption and where, and not merely speculation and conjecture? We would if we had.
Can I answer that one? I love that question. Look, there isn't, I don't know of a publicly available database. That's sort of what we're talking about with these bills, but the information is out there. People have it. Okay. And there are people in this space that do business and work in this entire space of NIL deals. So it's not like the information isn't there. It can be gathered. It can be obtained. There are some, I've even seen some folks gather it and, do little summaries on the types of transactions that this group of deals that they looked at involve. So in a summary fashion, in other words, the individual deal itself isn't like being publicly revealed who the athlete is and the amount and all that. So in terms of like go to the internet and pull up public consumption, no, I'm not aware of that, but like I said, there are people that have it in the space. So.
And we're largely relying on them, right, Rick, to provide a lot of that information, which is right.
And schools. I would just add schools, Julie. Schools have the information too. A lot of them do. They don't have all the information, but there are many schools that their athletes are disclosing their deals to the compliance department for sure. I mean,
and I think it's important to note too, Julie, that I would say the majority of NIL deals are above board, good, fair, decent deals, and we want to counter the rhetoric out there. And there are some bad things that have happened. There's no doubt, right? There's bad things that have happened recruiting for 100 years. But to vilify all NIL deals, to say something like President Charlie Baker said, everybody lies and all NIL deals are bad, those types of things that he alluded to, it's not fair. I would say the vast majority of them are very good. If there's a way to maybe harness that, monitor that better, that's worthy of discussion. But I often find that the media and some of the NCAA crowd and apologists are really trying to focus on those few bad ones that have happened.
Right. Well, we'll see if we have 30 seconds. Go ahead, Gemma.
Oh, that's fine.
Okay. Last one. Seems to me there's a consensus that athletes should not be classified as employees. Do you see a bootstrap of something like this to the international student bill that could pass swiftly, or is it quick standalone? Dave?
I mean, again, I think the employee status issue is one that's still worthy of debate and one that is going to be decided probably over the next few years. But from the international perspective, I think that's going to pass on its own. I think it's just fair. We're recruiting these international athletes to come here. They should have all the rights and privileges of any other college athlete.
All right. Before we wrap up, Gemma, Brandon, and Donna, anything to add to that? Rick? All right.
Good luck with that question.
I would just quickly say that a lot of these bills have a lot of very good things in them. And I would really like to see Congress come together and pass a sensible but fairly limited bill that helps us preserve what we love in college sports.
Thank you, Gemma. And with that, we will end our 29th webinar. Thank you all for attending. And thank you to all the panelists for your time and expertise. And please don't forget to join us for our next webinar on December 7th on NIL education, our college athletic programs delivering. Same time, same place. Thank you all. Have a great week.
Thank you, Julie.
Thanks.